Here for our Board of Equalization. We appreciate everyone coming. Commissioner Gardner is at a conference and not unable to phone in at this point. Oh, maybe she's here now. Yeah, double check, make sure. Commissioner Gardner, can you hear us? There she is. Okay. Then with that,
Can't hear.
we'll get started. We have Commissioner Gardner by Zoom, Commissioner Sackridge, Commissioner Lee here in the room. And we'll go ahead with begin the review of the regular agenda. I have looked at the minutes for item 1 and 2, the process reports for number 3, as well as the hearing process report for number 4. Are there any questions on those items that we need to discuss?
Not for me.
Commissioner Gardner? Okay, a motion?
I'll make a motion that we approve agenda items number 1, 2, 3, and 4 as stated in our regular agenda.
Commissioner Gardner, I can't hear you. You're muted.
She's got to change her.
Nope, still can't hear you.
Commissioner, if you changed your microphone source, maybe that's the problem?
Still can't hear
Still
you.
can't hear you.
Now, we sometimes talk about the good old days when we didn't have to have technology, but then again, I enjoy air conditioning and heating when I need it.
Yeah. Okay.
You know what? I wish you could call in by phone and just do it that way and observe by Zoom.
Commissioner Gardner, would you like to just call in on the line? Would you like me to send you the call-in number for you to call on your phone? Okay. All righty. All right.
I've been reminded that while we're waiting for this to get connected, if you haven't signed the guest roster, would you please do that at the back corner podium when you get ready to leave? Thank you.
Here we go.
All right, can you guys hear me now?
Now we have a nice echo.
How about now?
That's much better.
Okay, I think we got it figured out. A little bit technology glitch, but we can make it work. Thank you, Bert, for sending me that information so that I could call in and have audio.
Okay.
So with that, I will second that motion that Commissioner Lee made.
Okay, all in favor of approving items 1 through 4, say aye.
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 Aye, that passes 3-0. Before I go any further, Adam Beck, Ben Stanley, can you hear us and can we hear you?
Yes, I can hear you, Commissioner.
I'm staying there.
Got it. Thank you. Okay, we're on item number 5, approve or deny reinstatement of the primary residential exemption for parcels listed in the attached spreadsheet for tax year 2022. Any comments on that?
Clarissa Surrey with the Assessor's Office. We would recommend approving these.
No issues there. Okay. Okay. Comment?
I'll make a motion that we approve number 5 as stated on our agenda.
I'll second that.
All in favor, say aye.
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 Aye, that passes 3-0. Number 6, approve or deny a new application for property tax exemption for the Intermountain Healthcare Personal Property Account Number 103157. Is there here someone to speak to this?
Glad to be here, Commissioners. Francis Gibson, I am the CEO and Administrator, Spanish Fork Hospital, and with me I have Nate Runyon, our legal counsel, to kind of go through the case from that perspective, probably better than me. But I did want to appreciate the time to be here to visit with you. Commissioner Gardner, sorry we've not seen you here live and in person, but you look good wherever you're at. So with that, I'll turn it to Matt.
Thank you. As to the application, there was a misunderstanding on the original application that was submitted with the Spanish Fork Hospital in 2019. The assessor's office and the clerk's office, the exemption for the real property was granted, but the exemption for the personal property was not granted in 2019 at the time. We believe that there was just a misunderstanding there, that it was requested. There was some discrepancy on what was included in the application. But regardless, the exemption wasn't granted. And so we've been back and forth with the clerk's office and talking through this issue. We believe that it should have been granted. Now the board does have authority. We've submitted a new application just to cover the bases. And in that new application, the board, under the statute, certainly has the authority to waive the original application requirement, the annual filing requirement. And because the board has that authority to waive that, the board can consider this new application now. I spoke with Mr. Jones and understand that this application would technically be considered late, but because of the statute allowing the Board of Equalization to grant a waiver, that shouldn't be an issue. The board can grant the waiver and say that this application is fine, can take up this application here. So our thought is I can go through all the facts and give you a presentation on why we think that the original application was sufficient, but I don't know that we need to spend time on that because you have a current application before you. There's no question that Intermountain Healthcare and the Spanish Fork Hospital meets the charitable requirements. The real property was granted the exemption, so there's no reason that the personal property wouldn't also be granted. So we believe that the board has the authority to go ahead and grant the exemption based on this application that's before you now. Again, I can go through and address some of the issues on the old application, but I don't know that that's necessary. We need to take the board's time to do that.
So Paul, do you have any concerns with that?
Yeah, I mean, there is a timing concern here. These applications should be in the first part of the year. The board's supposed to make determinations by May 1st. Obviously, we're well past May 1st for the 2022 tax year. I agree with Mr. Runyon that obviously the real property is exempt. As far as the qualifying for an exemption, there's probably no question. IHC is one of our charitable partners here in the county, and so there's no question that the use qualifies it. One of the really important reasons that these get done in the early part of the year is that the value of the personal property for IHC, it's actually part of the valuation for all the property value in the county, and then the certified tax rate is determined based on the allowed revenue, taken into account with all of the property that's to be valued, determines the tax rate, and that's what everybody pays to get all of the taxing entities their full revenue. And so by doing a late exemption, it actually reduces the revenue that all the entities get because the property value was part of the valuation. And so had it been exempted, the certified rate would have been 1/100th of a point higher without the,
So what you're saying is that
property,
other
but-
entities are basing their current budget, which started the 1st of July, on the anticipated revenue.
right. So if you grant this for the 2022 tax year, that revenue was expected by everybody, but it won't be received. That's the real downfall at this point to all the taxing entities.
Yeah, and to that point, I actually think that the personal property statements were not submitted until later because Intermountain thought the exemption was granted. So even all those numbers, I don't think Mr. Jones is right, but I don't think those numbers were in there for Spanish Fork Hospital because there was no filing that was done to include all those personal property numbers for 2022. So it actually, in this instance, wouldn't have been in the certified rate. So I don't know that it actually would have an effect on the property tax. That notice in the invoice wasn't issued until I think it was September or October, well after the certified rate was already done. So in this case, that's normally a concern. I totally understand that, but I don't think that the taxes are affected by this issue. But, and I can read to the board the statute that allows for the waiver under 59.2.1102 subsection 3B. It says, notwithstanding subsection 9, the County Board of Equalization may waive, 1, the application of personal appearance requirement under subsection 3, 4B, or 2, the annual statement requirement under subsection 9C. So that annual filing can be waived by the board.
I think
And then-
we're fully aware of that. Yeah,
Yeah.
that's
So,
not uncommon for us to know that.
so the board definitely has the authority to waive that and consider this current application. And where there's no dispute that the property should be exempt in the charitable standards, we'd ask that the board would take that under advisement and grant the exemption.
I'm just wondering if Chris, do you have any comments to this at all, or any thoughts?
Chris Polson, County Assessor. I agree with the analysis that Paul did. I'm trying to recall. I believe personal property is a little different in the tax rate setting process because there have been so many estimations done in the past. I believe the legislature may have moved personal property to the prior year to be used in the calculation. Is that, yeah, I'm seeing some head nodding here.
That's correct. Bert Harvey, Auditor's Office. As part of the rate setting process, actually personal property, the value that goes into setting the current year's tax rate in terms of personal property, factoring into that, we are using last year's value. So when we set the rates for 2022 this year, we would have used year-end values from 2021 as part of that rate setting process. So in effect, granting the exemption for the personal property account probably would hold harmless the rates and the in terms of like the value, but this still is expected revenue that will now disappear. However, that's not unknown that's not unusual as we go through the BOE process. There's, values get adjusted down after the rate's been set, and it all kind of goes into the mishmash of the rate setting process. So I don't know there's necessarily a huge harm here. The only thing at argument at this point really is the correct process by which the board grants an exemption. This account wasn't created until 2021. The first billing would have been 2022. In order for the board to grant an exemption, it should have been included as a new application this year. It was not. Obviously, IHC thought they had done that and fulfilled the requirement. Obviously, we didn't see that. We weren't looking for a personal property account for Spanish Fork Hospital because it hadn't been brought before us. So, it's probably just a kind of a general, lapse of everyone all around on this one.
So what do we have to do to make it so that's right, so we can get it done today?
In the auditor's office, from our opinion, honestly, I would feel like this shouldn't be granted by the board because again, we're outside the normal timeline for granting it. But that's not to say that the tax that necessarily I think IHC owes the taxes because of a technical aspect. I personally feel that this should be taken before the Board of Commissioners on a greenfield request and have the board forgive the tax because based off like we've done in the past with say the Seventh-day Adventist Church, which they missed their filing and were then rolled back and made taxable, which that wasn't something the Board of Equalization was able to correct, but it was something that taken before the Board of Commissioners and their legislative authority was able to do. That's
So
I feel should be the proper role. But
So I guess what you're saying though is if we approve it, then it can be appealable still to the state.
yeah, but I'll say that the auditor's office probably wouldn't go that route. I don't know that we'd want to spend our time on this, but I just feel that the proper role for granting this exemption would be through the Board of Commissioners now, since we are past all the filing deadlines.
And I could see that. I could see that that's a route that we've taken multiple times.
Yeah.
To
I
get
think if
there.
it was
But in this
just-
case, I'm just wondering if we don't just grant it, and we don't have to have another meeting. I mean, I don't have to have another meeting, but it just seems like we just kind of move forward.
What again, what Bert's saying here is that it's possible the auditor may go back and say, we're going to appeal this to the state. And right now we think that it won't happen based on what we know about what has happened, has occurred here then. Is that correct?
Well, the other aspect is typically when we do that, it's just based on a past, just passing the deadline, missing the deadline. But in this case, it was an error in the way the application was processed. So there was an actual error. So where this is similar to what we did with the Seventh-day Adventist Church, it's also a little bit different in that there was a technical error in the application.
Mm-hmm.
And the one other point that I will note is in the statute, it says that the Board of Equalization has the authority for the waiver in 59.2.1102. It's actually this body that has that authority to waive the filing requirements. And it is this board that has the authority to grant the application as well. So I do believe it would be appropriate for the board here to grant.
So in listening to that, I think it would be imperative that we actually use that language, in the motion that, and I don't know, you guys can tell me the code to it, so that if we were to go down the route of saying we're going to approve the application, not just say that, versus
Base it
on 6, but actually, put in there that we're waiving, we as the board are waiving that late filing and moving forward that way.
That's exactly right. So our request would be that the board under 59.2.1102 waive the original application filing by Intermountain for the personal property charitable exemption, and then grant the current exemption application for personal property before the board today.
So moved. I like the way you put that. Can we just say so moved?
There you
Does
go,
that
and
include
I'll
all of
second,
that?
and I'll second it.
I'm writing this down because I want to make sure I get the homework right. All in favor, say aye.
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 Aye. That passes 3-0. Thank you
Thank you. Thank you for your time.
Thank you
everyone
for
for that
guiding us through that
discussion.
motion
That's
using
helpful.
legalese.
Okay, number 7, approve or deny petition to the board to hear property evaluation after filing deadline for parcel 0002, appeal number 1372 for 2022. Comment, Bert or Chris?
Sorry, I believe most of these were continued last week because most of them were all of them except for number 9 were dealing with possible factual errors that we deferred to the assessor's office as to whether they would agree, and if they were, then they should be accepted.
Okay.
And I believe that's items number
7 and 8.
7 and 8.
So is the
Number 9 is a new one. We haven't dealt with that one yet before.
Yeah, then we have number 10, okay.
Clarissa with the assessor's office again. 7, I'm covering. And my notes say extraordinary or unanticipated, but it doesn't mention any factual error. So I don't
They claim
know.
that you're valuing the property as if the utilities are stubbed to the property.
Right. That was
And they're claiming that the utilities are not stubbed to the property, and that would be the factual error.
Thank you. Yes, this one is a potential factual error. This is actually mine. So yes, This one is a potential effectuator, so we would recommend approving it.
I'll make a motion that we approve item number 7 on our agenda.
I'll second that motion.
All in favor, say aye.
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 That passes 3-0. Number 8, approve or deny the hear of property valuation after filing deadline for parcel 0015, appeal number 1377.
And this one was a question of level of completeness.
Yeah, they didn't provide enough evidence for us to be able to know whether or not there's an issue. So we would recommend approving this, and then we can try and get that evidence.
Okay.
I'll make a motion that we approve agenda item number 8.
I'll second that motion.
All in favor, say aye.
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 Aye. That passes 3-0 as approved. Number 9, approve or deny property valuation after filing deadline for parcel 0015, appeal number 1384.
This one is also an extraordinary and unanticipated circumstances. Sally spoke to this person on the phone. I've reviewed their application. Their circumstances seem to meet that standard. It's pretty extraordinary, and based off of what information we've been given by the appellant, it sounds like the circumstance quoted in the application was significant enough to delay filing.
Good.
I agree. I'll make a motion that we approve agenda item number 9.
I'll second that motion.
All in favor, say aye.
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 Number 9 passes as approved. Number 10, approve or deny application for review by Board of Equalization of Farmland Assessment Act status for serial number 00858, count number 194, TAC 2023, and is continued from November 21.
Good afternoon, guys and ladies. I have spent many sleepless nights over this situation, headaches. And I wrote down a speech, so I'm just going to read it. After further educating myself about the local greenbelt and urban farming, I find both to be pretty egregious. As such, I have no desire to participate in either program. I am, however, requesting that the rollback taxes be dropped and the lien on my property be released immediately. I also would like to opt out of paying school taxes, since I have no children in school anymore, on my property taxes. And finally, I would ask that you consider equality on the irrigation rates, since the water is all being used for the same purpose. This property has been in my family for almost 80 years. I'm the 3rd generation to live in this home. I've lived there for the last 8 years, taking care of my elderly parents until they died, at which time I inherited the property. Up until that time, the property has absolutely complied with all greenbelt requirements. As such, the imposition of rollback taxes is frankly unjust. Taxes have been paid accordingly. We are at an age where we are living on Social Security. We no longer use schools. Our children are grown. Therefore, we ask that we remove the school taxes from our property taxes. And lastly, I would request that fees for irrigation water become fair and just, regardless of being on the green belt, because I paid 3 times as much last year as I would had I been on the green belt. So, my property is a farm, whether you declare it such or not. We, the people, are being forced to comply with social governance by taxation. Under God, the people rule, and government is beholden to us. You're dictating that we either comply with market value property tax rate, of which over half goes to a school district, or comply with Greenbelt's stipulations of producing for profit so that our work enters the market that we are striving to be free of. Either way, the intent is to rob us of the little we have by enslaving us to government. No more will we be silenced or scoffed at when attempting to assert our God-given rights. We, the people, are tired of being overtaxed by big government. That's it.
Did we discuss the
Commissioners, if I may, this is Ben Stanley with the County Attorney's Office. Well, we're certainly sympathetic to those views. As you probably are well aware, there are benefits to even people without children to have taxation for school districts. It's not something that we have discretion to waive or allow residents to opt out of. No one questions whether this property was used as a farm. The reason it was removed from Greenbelt status was its failure to maintain 5 acres with the residential exception under standard of practice 7.3.1. The home site and property used in conjunction with the home site's excluded from the mandatory 5 acres. And so this one simply, as the home site grew, fell out of eligibility for Greenbelt, which is why it was removed from Greenbelt status.
Have we discussed urban farming options?
Yes.
I don't want to do that.
Yeah,
I
those
don't
options
want
have
a
been
lien on my
discussed.
property. I think the rollback taxes are so unfair. I can't even believe it. I have 5.25
And of course,
acres. It is a farm.
And of course, the rollback taxes are assessed by state law and can't be waived.
And I think, what is it, the actual farm is if I understand it, that's of the 5.25 acres you own, right? About almost 80% of it is residential, and that was the underlying
No,
issue.
that's not true.
I'm just trying to remember from what we talked about
It was,
3 weeks
they
ago.
said 0.81 of an acre is residential. I don't know who came up with that number or where that came from, but
And the calculation was provided by the county's farmland assessment analyst. There's a photograph that shows the measurements and how that was calculated in the assessor's exhibits that were submitted with this agenda item.
Yeah. Yeah.
well, what you call a farm and what I call a farm are obviously different because I know what my property is used for and how much of it. My home takes up about 0.04 of an acre, the house itself. I have a little front yard and I have a small backyard and a very narrow back piece on the side of the house. That's it. But anyway, I just wanted to let you know we're being overtaxed and you guys are in a position to maybe do something about it. And I think if you know deep in your heart the time is approaching,
So
but we're going to be held accountable.
here's what we can do and what we can't do. We could go ahead and approve this. The challenge that you'll face is that you'll have to go argue it before the state tax commission,
That's fine. I'll argue.
and then they will make a decision. If you I mean, because I can look at this and say, I wonder about the trees that are in there that are in this yellow area. And you've seen this map, right? So you know what I'm talking
and
about.
it's
Okay.
not even correct. I mean,
So you could go
okay,
argue that, before the state.
Yeah,
and-
I could, but okay. As my objective is to get rid of the rollback taxes. That's what I want. Because I feel like they're unjust. Like I said, this property's been in my family for 80 years. We've paid our taxes. It's always been in the green belt. I own 5.25 acres, which should qualify for the green belt. I was told that. That's why my dad left me that amount.
Right. And that's true. But your dad also liened the property when he signed the agreement for the to be in greenbelt status. And so
Yes, he did.
It's conveyed through.
Right.
And so he knew that he had to keep it in greenbelt, and he had to keep it as a farming operation.
Yes.
And it looks like he did. And good for him. He did a great job of keeping it in a farming operation. I guess the question comes up when it transfers hands, then there's a reevaluation. And that reevaluation is saying now that you have to have 5 acres in greenbelt. You have to be producing on 5 acres, and 1/4 acre can be your home.
I realize.
And that's where we got this hiccup.
Right.
And so, I mean, the county commissioners, we could say, we agree. We agree with you. I'm not sure about that. I think the house is there. I'm not sure about the back. I'll take the rows of trees off, and we approve this. But it will continue to go to the state as more than likely. More than likely would go to the state and be appealed to the state, and then they would be the ones, and they'd make a decision, and then it wouldn't matter what we said, about that.
Right.
So that's the option. We did explore the other option a little bit on the urban farming side because of the 1 acre. You said you don't really want to go to the urban farming side.
No,
There's no way to pick up some more property. I think this commission is probably as friendly as I've ever seen in the way of trying to work, especially with a farm that's trying to produce. And I truly believe that. I'm not just saying that. I don't have to say anything anymore. That I can say whatever I feel. And I truly believe this commission has tried its best to give as much compensation as possible to keep it going. But there are some rules that we have to abide by and live under. And a couple of them is the 5 1/4 acres with a 1/4 acre, and those are just the standards that we have to apply equally, because we can't say, sorry, yours is different than yours, and then that gets us out of balance.
okay. I'm not requesting to be on the greenbelt, right? You know that.
Okay. So in that case,
All I want is the rollback taxes gone because I think it's unfair.
then your only other option for that is to take it to the Board of County Commissioners I'll just run through the scenario. So we deny it. We deny the application according to what you're saying. And then you'll be assessed the rollback tax, and your only other option is to appeal it to the county commissioners. Now I realize that's who we are, but not in this body. You'd roll it, and then you'd make your case before the county commissioners on why you think you don't need to pay that rollback tax, because the county commissioners do have the option to modify, change, or forgive that tax. Your chances of getting that to actually work are probably very slim, because then what we'd have to say is to others who have gone and paid their rollback tax, we're going to treat them differently than you'd be treated. And so that's hard. It'd be really hard for the commissioners to do that.
Have the other people owned the property? Has it been in their home or their family for 80 years?
Some of them,
Third generations? I mean,
yes.
Some of them have, yeah.
Yeah.
Some have been here since the
I just, that's just wrong. That's just wrong.
Yeah, it's
This has been Sam again. If I could interject one more time. One thing that I think the public sometimes doesn't understand about greenbelt and rollback taxes is that it's actually a way to adjust for the tremendous benefit over 80 years of paying such a reduced tax. And so we just go back 5 years to assess the rollback, but it really is to make it more equal with everyone else and more fair to everyone else to assess that rollback over 5 years, when the benefit has actually been occurring over 80, many, many, many decades of preferential tax treatment, if that makes sense.
My daughter just brought up a point. In the law, it says that the rollback taxes can go up to 5 years back, but you have the authority to reduce that time as well.
We've handled other properties where they've deliberately sold it for other reasons, and they've always gone back 5 years for that back tax. Was there any exceptions to that, Paul?
Well, just off the top of my head, I think that's probably referring to if the property's been in Greenbelt less than 5 years, then we would only go back the number of years you've been in Greenbelt up to 5 years, if that makes sense. If you've been in Greenbelt 2 years and then you get withdrawn, we would only roll back 2 years. We wouldn't roll back more than you've been in it. But.
Sure.
So the fact that my father left me 5.25 acres so I could stay in the Greenbelt is moot, I'm hearing.
The only way they work that is if more of the land space was used for actual agricultural
Okay.
or cattle.
The farm has fallen into disrepair, okay? since my father was so old, he let things kind of go. So we have a lot of work to do. Barns to rebuild, corrals to rebuild, pig pens, everything's got to be redone, fences put up. So that costs a lot of money. And then to have to pay a rollback tax of $7,500 on top of that, to me, is just appalling. And it doesn't help anybody.
It helps our government to grow bigger.
True. Which is what we're tired of, all of us. All the people are.
No, I know.
We need help. And you guys are in a position where you could help.
Yeah. Problem is we are actually, the county is a subset of the state. It's actually more directly tied to the state than even the cities are. And so we're compelled to operate under state statute. And so we're kind of put into a box of what we're allowed to do.
I understand that. And that's happening throughout government everywhere, isn't it?
Yeah.
And I don't think it can't keep going the way it is and maintain itself. You know what I mean? It's all going to come crashing down very soon.
Well, with that, with you not wanting to be in Greenbelt, I'm gonna make a motion that we deny the application, and then if you'd like to come before the commissioners later on and talk about the taxes, you can. But I'll make a motion that we deny the application.
So what does that mean exactly? What's the application?
Your application that you have right now, that we're reviewing, it's the farmland assessment, the Greenbelt status that's in there. And so I'm going to deny the app because you put forth an application to, what does it
I
say
never
here?
put forth an application
I'm
to
sorry.
enter the
It was-
Greenbelt.
Diane was the one that rolled it back. And so we're saying is in our agenda, it says approve or deny application for review by the Board of Equalization and Farmland Assessment Act.
Oh, that's what I sent in the mail.
Yeah.
Okay. So why is it that if I'm a farm still, I own 6 shares of irrigation water, I'm not in the green belt, why do I have to pay 3 times the amount for irrigation?
Because there's no longer ag use is what the problem is.
So what am I using it for then?
Well,
It
I mean,
is ag use.
This is a
But it doesn't
irrigation
benefit the
company
state,
question.
correct?
Yeah, this is an irrigation company. I don't know who are you getting your water shares from?
Strawberry water.
Yeah, see, we don't have anything to do with.
But they
the
told me
prices
if I'm
and-
not on the green belt, I don't get the discount. You pay
That could
3
be
times
true.
the amount.
Yeah,
How is
I
that
don't know.
fair?
Yeah. The problem is that, again, we've had so many homes, so many farmlands sold so they could be developed that I don't know when the statute was written that it had to be 5 1/4, but the state law required anything less than that, then it has to be considered no longer greenbelt status. Again, because so many have been selling their land to be developed, they're getting the benefit of high dollars for the acreage that they own, that in order to maintain greenbelt status and avoid a runoff of selling of land and make greenbelt really a greenbelt, the state was very stringent on the 5 1/4 acres standard, of which 5 acres had to be actual agricultural use. And that's why the 5 years rollback was part of this, was to help ensure that if there's going to be a sell-off of land, then the farmers who were farming, who no longer want to be farmers in some cases, then they know what they're going for when they do sell the land for an apartment or a home or a business complex.
Staying in farmland.
Yes, and so that's why the
So-
emphasis is keep it in farmland.
So let me ask you this. If I were to lease all my excess property to the gentleman who bought our property, would that keep it in the green belt?
We'd have to rezone that whole property, so they basically would whatever, if your property's here and his is here, then he would cut you, that land would.
No,
cut
no,
out.
that's not the case. So if you were to lease your property that is not your home, so if you, for example, had like a fence around your home, and as long as that fenced in area is less than a quarter of an acre, if you were to lease the rest of your property to someone else and they were to utilize it for growing hay or sheep or whatever they're doing, and there's production proof and you've got a lease, yes, that would qualify you to stay in Greenbelt because it would be used. And so you would just need to have a way to show the county that there is production happening on that land, whether that's through livestock days of livestock grazing on it, or whether there's actual like production. So leasing it out though for farm use, as long as you have a record to show that that's what's happening, is a qualified use of Greenbelt.
Okay. Do whatever you got to do.
So from what I see here, what I see is that the fact that you're using it as a farm is not in dispute. The only thing that's in dispute is that the part of your land that you are using for residential purposes is more than a quarter of an acre, is what they're saying. Now you could also lease it out. You could also lease it out and you could also lease it out and have that considered the Urban Farming Act too. The only difference is you would just have to prove that production every year.
See, and I don't want to have to prove anything to anybody. I want to use this land to support myself and my family. I have 11 children, 36 grandchildren. That's what I want to do. I want to feed my family.
Yeah, and so you actually can. So I did the same thing when I had my farm. I had what I would do is I would keep track just in a notebook of how many wheelbarrows of food I was pulling out of my garden, because I have 5 siblings and my mom and my in-laws, and we have over 25 children amongst us. And the vast majority of what we grew and raised on our farm, we consumed. So, for example, we raised sheep, and then we would bring the sheep to the butcher, and then we never sold the meat. We ate it, or I gave it to family and they ate it. And I just had to keep track of how much I was producing and then provide that to the county. I didn't have to show receipts for everything that I did. But having it in Greenbelt, not only do you get the property tax benefits, but the pain that you have to go through to try to track that actually will help you in your income taxes as well, because it costs more to run a farm for personal consumption oftentimes than you actually make. And so what I found is keeping track of all the food that I had, plus I kept track of how much money I spent on seeds and how much I spent on fertilizer and how much I spent on wood chips. I kept track of the fuel that I put in my 1-ton truck, and I was able to write all of that off on my taxes as well. So the little bit of documentation that we're asking you to do to show that you're utilizing the land for production would actually be good documentation for you to have when you file your taxes, and you can get benefits from your income tax federally and state as well for running the farm. And so, like, if it were me personally, if I were you and I was going to lease it out, or if I was going to continue to do production, I would go through the pain of documenting that and then getting the Greenbelt status just so that you can have those benefits. Even though it's frustrating to have to do that, I think the benefits outweigh that. So this is like, if I were in your position, this is what I would do. I would ask us as commissioners to abate the rollback for 1 year. And then I would use that 1 year to get production. And then a year from now, come and show production. And then as long as you get entered into the urban farming, then we can then abate then we can get rid of the rollback because we see that you're farming. That's an option. Other than that, you will have to prove that the part of the property that you live on is no more than a quarter of an acre. But I think that there are options, but you do have to do the documentation work to bring it to us in order to get the Greenbelt status, which basically gives you significantly lower taxes. But all that work you're doing for the lower property taxes, you can use to your benefit on your income tax as well.
Did you get that? Did you get all of that?
I think so. I'm going to ask my legal counsel. What are your thoughts?
You almost want to go on the Greenbelt then.
Well,
You get cheaper one.
that's your only option. That's not what you're saying.
That's not my only option.
So the only problem that they're with what she presented is you still have to show that 5 of it is being used.
Uh-huh.
Well, they come out and took pictures and declared it without talking to you, without,
I know.
you know.
No, she's talking about the urban farming.
Okay, so she has to, the property has to produce 80% of her income based on the land that she has to qualify for anything, as it sits, unless she makes modifications to reduce it to a 1/4 acre. That's gonna be very difficult to come up with 80%.
Well, I don't know where you're getting the 80% of her income.
The education we were sent home to conduct.
She helped me research with all the paperwork you sent me.
Sorry.
Hi there.
Hi. Just to clarify, the 80%, as you stated, is in statute, where it says if you have less than the 5 acres in production, and you can prove that 80% of your income comes from that, then it does qualify with less than 5 acres. So that is a part of the statute, yes.
Okay, now I get it.
Anyway, we have not even looked at that as a calculation or anything at this point, so.
So what are you recommending, Chris? Is there something here
I
that,
didn't know this was gonna come up. But we would need documentation of previous levels of incomes through the IRS, so it'd be tax returns and those types of things to document what's been produced and what's going forward. We could do some estimations. I say estimations only with the fact that I believe you just received the property based on, yeah. So
that'd be
there's no
brand new.
history there because we've had a change in ownership.
Right.
Yeah.
So the past income wouldn't really apply because they weren't the owner.
You would have to make a huge consideration going forward based on estimates and those types of things going forward, but a calculation could be performed. So,
Either way, so I think that in order for the agenda item today, and I may need some help with Paul and Chris and Commissioner Lee as well, but what I'm thinking is we either need to continue this to a future meeting so that you can have time to explore the 80% option and how we would estimate that, or we could defer the rollback for 1 year and then give you a chance to come into compliance with some sort of a greenbelt, whether it be urban or standard. And then if you come into a compliance, then you can apply for an abatement. If you don't come into compliance, then you still have the rollback, but we've deferred it a year, giving you an opportunity to come into compliance.
Okay, yeah, let's do that.
I'm not sure we can do the defer for a year. Paul, maybe you can.
Yeah, that's right. That'd be a board of commission type of decision to defer.
Okay.
So I mean, if you wanted to go that route, you would just probably need to deny it and then work through the board of commissioners as they work through whatever, getting on urban farming or whatever. As to the 80% income, yeah, you would need to continue it today and submit proof of income and production to figure that out.
No, it won't be 80% of our income.
Well, the thing of it is that he's not selling it, so how do you value it? You know, she's growing it for the family.
The production that you produce off of it would have to be 80% of your income.
Right, but how is it valued? Do you have what a carrot's worth? You know, I mean.
Yeah, I don't know how.
do we-
I think you would need to sell it. I think that's how you would determine the value of it is through the sale of it.
Yeah, that's not what she's trying to do.
yeah, within this scenario, what has been presented so far is the product is actually being internally consumed. Is that?
Yes.
Yes, I think everyone's agreed to that.
it's not going to open
So,
market, it's just internal to the
if-
family.
Family.
If it's internal to a family, which
Yeah.
when you try to say 80% of your income is based on the product that's being produced, that would be very difficult.
I'm not going to do that.
Yeah, that would be very difficult
Yeah, I couldn't do that.
to calculate.
Unless I raise.
Okay, so what if we do
cows or
this? What if-
something, pigs?
What if
Yeah.
we deny the appeal for Greenbelt, but then you fill out an application and call, you can point her in the right direction who she needs to work with, that would allow you to ask the Board of Commissioners, which is us but in a different meeting, in a different capacity, to defer the rollback for 1 year and give you an opportunity to get on urban greenbelt. And then in 1 year, when you come back and show that you're on urban greenbelt, then you ask us to abate those taxes.
Can we abate 2 years? It'll take a while.
That's if you can. I mean, can you prove production for the last year? Can you prove production?
Well, I raised pigs. I've cut lots of wood and sold wood. I've done what I could with it.
But you barely acquired them.
Yeah.
Yeah, I mean that's
In disrepair.
so it'd almost be
How
2
many,
years.
how many pigs did you raise?
You'd have to be going forward.
2.
So you'd have to do production for 2 years, and then I think if you have the production, then you can come. I mean, it's a long haul to do that. I'm willing if you.
Now, for
guys-
urban farming, you prove production every year. So she could start now and prove production for next year.
Yep, and then you have
with
that
urban
production
farming.
proved, then you can prove it again the next year.
So would you go urban farming for 2 years?
Right.
And then go?
And that's why I say if we denied this application, but then you apply for, ask the Board of Commissioners to defer for 1 year. It gives you 1 year to get your production numbers up. Once your production numbers up, then you can get approved for urban farming. And you just have to track that. It doesn't have to be sold. But you do need to track. You know, how many hogs did you raise? How many sheep did you raise? How many pounds of produce did you produce in your garden? That sort of thing. I always did it by pounds, and then
Except for not in your garden.
and then head on livestock, because we made very little off of our farm. Most of what we did was internal, as well.
Given
And so I always just kept track.
given the amount of work, I want to.
Right.
We're gonna
And then
abate
after
one-
you've proven that production for a year and you can get onto urban greenbelt, then then you would come back again before the commission and say, hey, I'm back on greenbelt status. Can you abate those back taxes? And we could do it at that time.
So maybe I'll try to summarize. Let's see if we can summarize. If we go ahead and on this application, Paul would probably have to. We would probably have to continue it. I don't know how we continue it without date.
If we deny, we
Continue
don't
it.
have to continue.
If we
just-
denied it, then it would go straight. It would take it straight to the board. So we'd probably have to deny it. So we'd probably have to deny it,
I think we'd deny it.
and then we'd take it. Then you'd file an application to come before the Board of County Commissioners,
Which is you guys
which is us, just with different hats.
with different hats.
Yeah. Now we're sitting as Board of County Commissioners, not as members of the Equalization Board of Equalization. And then you come to the county commission, and then you say, this is, we got denied here. You'd like to get back on to Greenbelt, but it would be the urban farming status, and you'd like the county commission to defer for 1 year. I'll just say 1 year. Defer for 1 year the rollback tax, that 5-year rollback tax, so that you can prove production during 2023. And then you prove production during 2023, and then you come back to the county commission again and say, look, we've proved production on our land for 2023, and now we're gonna ask again for another deferral for 1 more year, 2022. So you have 2 years now of production on that land. And the problem that you're still running into is that you're looking at the 5 1/4 acres versus the urban farming can be 1 acre, and you'd have to make a decision on how you do that. If it goes to urban farming, then you have to say, we're going to do the urban farming application on this thing.
So I've got like 3 acres that are in pasture.
Right.
We just planted it into
Right.
pasture, okay?
Right.
And then the rest is orchard, is chickens, is the corral for cows, and then we have pig pens over here. So
Yeah, don't count the garden. So the pasture is an easy one because you're going to have cattle on there, right?
possibly, if we can afford it.
The cattle, or you have somebody graze it, or you have it cut, or whatever the case is, and you get some production out of it.
Yeah,
So there's 3 acres.
yeah.
So that, and the reason why I say the garden is because the garden is actually taken out of the greenbelt status. It's not part of they don't have that as part of it. It always gets cut out. The gardens do.
It's another thing that sucks.
I know it's strange, but I didn't make the law.
Wow.
I've looked at it
Who does
before and
make
said,
these
why in
laws?
the world you cut
Who
the garden
makes
out?
these laws?
Just as a side note, if I know cattle can be expensive, I found that the least expensive way to feed my family was with hair sheep. On 3 acres of pasture, you can raise probably a half a dozen hair sheep, and then if it's hair sheep, you don't have to shear them, and so it's a lot cheaper. But you can bring them to the butcher and have all that ground into beef, like you would beef, have ground meat, and we used hair sheep. It's the cheapest way. It's the most low maintenance way to utilize your land, qualify for Greenbelt, and feed your family.
Except we have to chase those buggers around all
That's
the time.
not officially. That's just my experience. That's what I found. Just FYI.
Thank you. Yeah.
So what we have to do then, if we deny this, is have you get set up so you can come back to the Board of Commissioners to set this arrangement up.
Okay, and where does that take place at?
The same room.
The same room. You guys
It's the
gonna have
same
different
place.
hats?
It's same
like
room, it's
sports.
just a different meeting.
If the
Yeah.
same people are playing one game, they're now playing a different game. So there's different rules that we have to abide by. So it's like playing soccer here,
And
but playing
poor-
basketball over there. So
Poor
maybe
Paul,
what we could do
our
is after
attorney,
this is
you're
done.
not the first person we've done this with. This is a process we've done before. Paul begrudgingly guides people through the process because it's not an easy process, but we've done it before. You're not the first person that we've had this happen with, and we've been able to successfully help people transition from Greenbelt to urban farming. And once they've been able to prove production regularly, we've been able to walk them through this process. So you do have to do some work in documentation of your use of the land for farming purposes. But if you do, then we can get you through this process.
So document everything I purchased for the property, correct? To, like, the seed that we just planted should be.
I even went down to the fuel for my quads, like my four wheelers that I used to put my spray tank on to go spray my cherry trees. I mean, the fuel, and in fact, if you buy a 4-wheeler so that you can utilize it, if you have a vehicle that's at least a 3/4 ton, you can utilize the payment for that vehicle as well. So we had a 1-ton truck, and you can take the payment for your 1-ton truck, the fuel for your 1 ton, any chemicals you use, any seeds you use, any fuel you use. You keep track of all of that, and then keep track of the pounds that you produce. So if you have an orchard and you're producing, 40 gallons of cherries, and each gallon weighs 5 pounds, then then do the math and figure out how many pounds of production you have.
Right, but
And if you keep track of all of that, not only will it prove it to us, but you can use that on your taxes,
most of our orchard
your
is
income taxes.
brand new, little trees. So they got to grow up.
Yeah. So,
Although I do have some big ones
right.
too.
So you won't have a ton of, right. But they also, we can also take that into account that, those are smaller trees, but that you're still, like I said, any spray you put on them, you can utilize all that, and it will help you for your income tax as well. So it is a pain to have to report it to the government, but that's the exchange that we have for getting the tax break.
So what we'll do when this is denied, then we'll ask you to go visit with Paul, and he can help get things set up for you. Correct, Paul?
The attorney's office might need an intern just to guide people through this process.
I'm starting to wonder, do I need an attorney?
I don't think so. You'll be fine.
I would hope that we can get you through this without having to spend the money on an attorney.
Me too.
We have no interest in
As
having.
Commissioner Lee said, this is a very farmer-friendly commission.
Okay. So
Denied.
So my motion still stands.
To deny, I will second that motion.
all in favor of denying this application, say aye.
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 Aye. That passes 3-0 as denied. Thank you. So we'll.
Okay, and then go work with Paul so that we can work you through the rest of it so that we can get you possibly transition to urban farming. Okay?
I want you guys' job. How did you get this job? Elected?
Yeah.
Okay, with that,
Motion to adjourn.
I will second that motion.
we are adjourned.
Hey, hey.
Goodbye.